Good afternoon, everybody. First of all, I want to apologize for the late start. We've had some technical difficulties that we're still working through, but we're going to go ahead and get started with the audio version of this. So this meeting of the California Underground Safety Board is now called to order. Secretary, please call the roll.
Bianchini.
Here.
Charland.
Here.
Del Toro.
Here.
Johns.
Here.
Johnson.
Present.
Munoz.
Present.
Voss.
Here.
Thank you. Before we start, I'll review safety information for those of us in here in person. In the event of an evacuation, proceed out the doors to the back of the room. Take a right into the atrium, walk past the restrooms, and use the P Street doors to exit the building. Our assembly point is across the street in Roosevelt Park. Welcome, everyone. The meeting will proceed in the same manner as meetings previous, in which we will have audience participation in person and remotely. We ask that everyone please be aware of crosstalk by ceding the floor as necessary to one another and each taking a turn to comment. When the chair calls for public comments, we ask that those attending in person who wish to comment please walk up to the microphone at the front of the room. Those attending via webinar who wish to provide public comment may press the raise hand function. Those who have joined by phone may dial #2 to be placed in a query by the host. When staff calls your name, you may unmute yourself and provide your comment. Thank you all for your patience and understanding as we meet today in this hybrid format. We will now proceed to public comments on topics within the board's jurisdiction that were not on the agenda today. If you would like to make a comment, please come up to the microphone. For those on the webinar, press the raise hand button or #2. We will start with the in-person comment. Please introduce yourself and who you're representing.
Anthony Headley, West Valley Construction. I would like to comment on the structure of this meeting agenda. Is it possible to put the comment section near the end of the session instead of at the start so that we can, in its totality, have opportunities to review the sessions in total instead of asking us to make comments on things or bring things forward we don't know that will be discussed or could be part of discussion today or tomorrow? Well,
you'll actually have time to comment during the meeting. So these are just for off-topic agenda items. Okay, thank you. Any other in-person comments? See no further in-person comments, we'll move to the webinar comments. Host, are there any webinar comments?
No hands raised currently.
Like I said.
Thank you. The next item before us is an action item on the decision on NOPV to Comcast of Northern California Investigation 21 SA 01472. Does any member need to excuse themselves from the consideration of this item?
Madam Chair, I need to recuse myself from this case.
Thank you, Member Johnson.
Madam Chair.
Thank you, Member Charland. Members that have recused themselves, please exit the room, and we will invite you back after action has been taken on this item. Thank you.
Madam Chair, there's quite a few cases that I would recuse myself from, so do you want me to do that up front?
I'll mention that on the next two, I believe. Yeah, thank you.
Thank you.
The notice cited Comcast of Northern California for violating Government Code 4216.3A1A, Failure to respond to the excavator by the legal start date and time. The NOPV proposes that Comcast be required to take our education course. Comcast has responded to the NOPV and pleaded no contest. Comcast is under the board's enforcement jurisdiction. We will begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone. For those on the webinar, press the raise hand button or #2 to enter the query. We will start with in-person comments. See no in-person comments, we will move to the webinar comments. Host, are there any webinar comments?
No hands raised currently.
Thank you. See no comments, we will proceed. We will turn now to members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we will then determine if the proposed sanction is appropriate. I ask that we deliberate on the proposed violation of Government Code 4216.3A1A. Failure to respond to the excavator by the legal start date and time. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin the deliberation.
Member Bianchini, I'll rely on the fact that they took a no contest, thereby capitulating to this and admitting that they have a violation. So I agree.
Thank you.
Member Munoz, I agree that Comcast of Northern California violated 42163A1A. I would like to make a couple comments. I would like to just kind of point out one of the things that I thought was something that we should look at as cautionary. The electronic positive response of 080 extraordinary circumstances existed, no locate due to weather, emergency, safety conditions. Mr. Wingate from 811 North had kind of warned us about this in the past, showing us that there was a huge increase in tickets that were marked with this. And it looks like they were using it because they were short-staffed due to COVID. I would like to maybe mark this for later, just because it doesn't seem like that was the intent of this. I did appreciate that the investigation pointed out the weather conditions. It was a beautiful day, it looked like, so the way that this is marked is that it was not weather, it was not emergency, and it was not safety conditions. So it seems pretty misleading to be using that. And I would like to, again, just call out to the fact that the call centers have been notifying us of this, and we probably need to mark this for future to make sure that we don't allow this to perpetuate. So when we start seeing these upticks of using this, we really figure out what they're meaning. Is it our responsibility to take a hit in public safety if people can't staff? I don't think so. They have a responsibility to staff appropriately. And I understand that the pandemic was something unforeseen, but I don't think it's a good excuse for not marking on time. That's all.
Thank you, Member Munoz.
Member Bianchini, may I also respond to that? I was going to bring it up later, but that's appropriate. These codes that are in there are codes that operators make up so they can communicate with themselves. They're not recognized in 4216 anywhere. And therefore, I don't think we should even consider that as any kind of an excuse. We've discussed this in the bill before, and the operators made this up for their own convenience, and we don't recognize it. Excavators don't recognize them. So therefore, it's a non-response for us.
Thank you, Member Bianchini.
I agree, and I think Member Bianchini and I have asked for us to do some exploration in the future about what these codes are, maybe standardize them a little bit. Perhaps in one of the future meetings we can look at that.
Any other member comments? Seeing none, now that we have discussed the violation, we may now proceed to discuss the proposed sanction. The NOPV proposes a sanction of mandatory completion of the board's education course. For those of you who find that a violation did occur, please state whether you agree with the proposed sanction. In doing so, please list the provisions of Section 4201 of Title 19 of the California Code of Regulations that you are using as the basis of your determination and facts you relied upon. Members who would like to continue the deliberation.
Member Voss here. I find that Comcast in Northern California was in violation of Government Code 4216.3A1A for failure to respond to excavator by the legal start date and time.
Thank you. Well, we're going to do a motion here in a bit. Are there any additional considerations for the record that a member would like to make before I ask for a motion?
As far as this, is this the second? As far as this one goes, I think that this one includes a financial penalty, if I'm not correct. I think we should discuss that in a little bit more detail, given the fact that we've been asked to consider the statute, and perhaps we can have a reminder of what the statute says so that we can kind of discuss this together.
I believe this is just, Member Munoz, just talking about the education. Was there a I don't recall the financial aspect of it.
No financial?
No.
Okay.
Any other comment?
No, I agree. I believe this was only the safety course, and it didn't have a recommendation for a financial on this one.
That's correct. See no further deliberation, we'll proceed to a motion. I will entertain a motion from the board to take action on this item.
Member Voss, I move to find that Comcast of Northern California violated Government Code 4216.3A1 and A and would benefit by taking the board's education course.
Member Voss, may I ask you to put the microphone closer to you?
Oh,
Hard to hear you.
do I need to repeat myself?
No, I heard you. Do you guys need it
We
to
good?
be repeated, or? I think we're good.
Okay.
A second. A motion was made by Member Voss. Second.
I'll second. Bianchini.
Member Bianchini, second. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini,
Yes.
Del Toro,
Yes.
Johns,
Yes.
Munoz,
Yes.
Voss.
Yes.
Motion is adopted. Thank you. The next item before us is an action item on the decision on NOPV to AT&T California Investigation 21 SA 01472. Members Charland and Johnson have recused themselves. Does any other member need to excuse themselves from considering AT&T? Seeing no other recusal, we will proceed. The notice cited AT&T for violating Government Code 4216.3A1A, failure to respond to excavator by legal start date and time. The NOPV proposes a financial penalty, the amount of which is to be determined by the board. AT&T did not respond to the NOPV within the 30 business day response period outlined in Section 4252 of Title 19 of the California Code of Regulations. The NOPV was issued on May 6, 2022. AT&T needed to respond no later than June 20th for their response to be considered. AT&T responded on July 5th. AT&T is under the board's enforcement jurisdiction. We'll begin by taking public comment on this item. If you'd like to make a comment, please come up to the microphone. And for those on the webinar, press the raise hand button or #2. We will start with in-person comments. See no in-person comments, we'll move to webinar comments. Host, are there any webinar comments?
No hands raised currently.
Can you confirm we have folks on webinar?
19 attendees.
Okay, wonderful. Thank you. See no comments, we will proceed. We will turn now to members of the board. We'll first need to decide if the violation occurred. If we determine that the respondent committed the violation, we will then determine if the proposed sanction is appropriate. I ask that we deliberate on the proposed violation of Government Code 4216.3A1A. Failure to respond to excavators by legal start date and time. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin the deliberation.
Member Bianchini, I believe that the violation occurred 4216.3A1A. There's a witness to it that had its ticket. Swinnerton was the builder and the general contractor to it, and also had a ticket in that did not get located, and therefore were a witness to the lack of clearance of the ticket by the appropriate time.
I agree with you, Mr. Bianchini.
Member Munoz, I agree that they were in violation.
Any other board comment? Now that we have discussed the violation, we may now proceed to discuss the proposed sanction. The NOPV proposes a sanction of a financial penalty in the amount of which is to be determined by the board. For those of you who find that a violation did occur, please state whether you agree with the proposed sanction. In doing so, please list the provisions of Section 4201 of Title 19 of the California Code of Regulations that you are using as the basis of your determination and facts you relied upon. Please also state what you believe to be the appropriate sanction level. Members who would like to continue the deliberation.
Member Bianchini, I certainly agree that safety training is in the board safety should be enforced here, and I will leave it to my other board members to the financial penalty.
Thank you, Member Bianchini.
Member Voss here. I think, this penalty phase has come up on other occasions with other cases in the past. And I think, we're at a point now where we have an entity here that's had previous violations. And so, in my mind, I think I'm willing to impose a small, not a grandiose financial penalty, but I think it's probably a good time to start this. And looking at time involved and everything, I think $1,000 would be appropriate, because I do agree that based on the report here that they did violate Government Code 4216.3A1A, and I don't think this was their first time based on what was communicated in the report.
Thank you, Member Voss.
Member Munoz, along the lines of Member Voss, I just want to kind of remind everybody that Government Code Section 4216-19E and 19 CCR 4201 asks us as a board to consider the following factors, which would be 1, the type of violation and its gravity, the degree of culpability, the operator or excavator history of violations, the operator or excavator's history of work conducted without violations, the effort taken by the violator to prevent violations, and once the violation has occurred, has the effort been taken to mitigate the safety consequences of those violations? So if we consider all those things, to Member Voss's point, this isn't the first violation. I think $1,000 is a reasonable start, in addition to the education course that has already been prescribed once before.
Any additional considerations?
Member Bianchini, I agree with that, with both Voss and Member Munoz.
Yeah. Chair Del Toro, I also agree with that.
And Member Johns, I agree. I did see it. AT&T has had education required before, so I think there is a justified by the history, and then also just the response. It seems that their response here was end of the day with a inclement weather at the end of the period for the request. I think that's not a good practice, so I concur with your suggestion or your recommendation.
Thank you, Member Johns.
Member Munoz, I think Member Johns brings up a really good point, and I know we kind of talked about it on the other one, but in case they're on the phone listening, I think there's the responsibility to use accurate markouts, as Member Bianchini had recommended. It's supposed to be for good communication, not for, misleading the excavator in their timeline.
Any further comments? At this point, I will entertain a motion from the board to take action on this item. On this item. So we need a motion.
Member Munoz, I propose that we accept that AT&T was in violation of, 42163A1A, and that we have a sanction of $1,000 penalty.
Can I get a second?
Member Bianchini, I will second that with another course review of the safety training.
Add the education course.
Yeah, that's fine.
Okay. Motion was made by Member Munoz. A second was made by Member Bianchini. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini,
Yes.
Del Toro,
Yes.
Johns,
Yes.
Munoz,
Yes.
Voss.
Yes.
Motion is adopted. Secretary, please invite the members that recuse themselves back into the meeting.
Chair, this is Operations Manager Tom Finn. Might I suggest a 5-minute recess, perhaps, to allow them an opportunity to return to the room?
Sure. Let's go ahead and take a 5-minute recess. It's currently 2:02. We'll return at 2:07. Welcome back. The next item before us is an action item on the decision on NOPV to Sun Country Systems Investigation 21LA01483. Does any member need to excuse themselves from consideration of this item?
Madam Chair, I need to recuse myself for that item, but I also have a clarification. Because there's quite a few cases on there, can I recuse myself other than walking all the way back and forth on the ones that I would be recusing myself on?
Okay.
Okay, so I would recuse myself for item number 5, 6, 8, 9, and 10.
Give me a moment here. So 5, 6,
8, 9, and 10.
All right, so we'll see you later. Thank you. Member Sherland, any other? I think towards the end there might be one. Yeah, okay.
Maybe I can get some clarification. So items 5, 6, and 7 are for 3 NOPVs based on one investigation, 21LA01483.
Mr. Marino, we can't hear you.
You are correct.
And so I just want to get some clarification about which cases you'd like to recuse yourself from.
In terms of cases, I guess there's 2 additional cases. Case number 21LA01483 and 22LA01484. 2 cases, so I will recuse myself from both cases.
Member Johnson, can you repeat that for me again? I apologize. So it's all the ones you just stated earlier? It still doesn't change, 5, 6, 8, 9, and 10?
One moment to get a clarification. The only conflict or issue I had was not with the city of Azusa, but as part of a case. And so since it's a part of the case, I would have to recuse myself of that. So for the remainder cases, I will be recused.
Okay. All of them. All right, well, go ahead and if you can step out. Okay, the notice cited Sun Country System for 3 violations. 1, Government Code 4216.2B, failure to notify the one call center before excavating. Second is Government Code 4216.4C1, failure to inform the operator of facility damage. And 3, Government Code 4216.4C3, failure to notify the one call center of a damage within 48 hours. The NOPV proposes that Sun Country Systems be required to take our education course. Sun Country System contests the NOPV on the basis that the violations were those of custom canopies. Sun Country Systems is under the enforcement jurisdiction of the Contractor State License Board. Our decision is whether to make a recommendation to the Contractor State License Board. We will begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone, and for those on the webinar, press the raise hand button or #2 to enter the query. We will start with in-person comments.
Good afternoon. James Wingate, Underground Service Alert of Northern California, Nevada. I wanted to make a kind of a generic comment related to this NOPV, but also others, which is the concept of board members recusing themselves about decisions. As you're all familiar, the law specifies the makeup of this board in terms of stakeholder groups being represented. I think a disservice is being done to operators who are having NOPVs and investigations against them if they do not have a representative who is able to vote. So I think perhaps you need to look at the requirements related to conflicts, or perhaps select a different representative who can provide the perspective of the operators when considering these violations. That's a very important perspective that's being missed from these discussions. Thank you.
Thank you, Mr. Wingate. Any other in-person comments? Seeing no further in-person comments, we'll move to webinar comments. Host, are there any webinar comments?
No hands raised currently.
Seeing no comments, we will proceed. We will turn now to the members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we will then determine if the proposed sanction is appropriate. I ask that we deliberate on each proposed violation separately. First, Government Code 4216.3b, failure to notify the one call center before excavating. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin the deliberation.
Member Bianchini, I'll start. This is another case of a general contractor who subbed out the actual excavation, groundbreaking and destruction of the utility themselves. So as to, I'm just going to make it simple, all of them, I have a no fault for him.
So we'll stick with this one right now. No fault.
Member Munoz, I think we've talked about this in the past, that there's a responsibility when you're scoping work to make sure that you are aware where the where the underground facilities are. I think that has caused unnecessary rushing of jobs, because that's not done when you're subbing them out. So you're subbing to the lowest bidder. The main contractor doesn't know where all the utilities are, and so now everybody's under rush. And I think that there is a responsibility for the main contractor to have the ticket and to verify the tickets. I've seen that in other cases that we've had before. We held the main contractor responsible, and I think that we set precedent for that. And I feel that they are in violation of the three, the not calling the one call center. They put it in their own contract that, what the expectations are. So it's clear that they knew that it is a responsibility to call 811. They did not inform the call center, and they didn't call within the 48 hours.
Member Johns and Member Munoz, you mean by the main contractor, the actual excavator in this case?
The
Sun Country Systems, the one we're talking about now.
Not the general, the prime, but rather the subcontractor that did the work.
We're talking about Sun Country Systems right now. The Custom Canopies is the one who did the work.
Okay. I was just curious. You said the main contractor, so.
She's talking about the general contractor. Yeah.
Member Bosser, just so I'm clear, the general contractor in this case, I think the way I understood it was Sun Country, who hired Custom Canopies to do the actual excavation. We saw some documentation in the file that had to do with the contract, and it was another entity that they put the responsibility of the ticket on, as I recall. But it seems to me that ultimately Custom Canopies, who did the excavation, would have had the responsibility to get the ticket because they were the actual excavator. But there's a lot of conjecture and stuff going on with the contract, and it's almost like the general contractor, Sun Country, didn't know what the heck they was doing. That was the appearance that I got. Ron, help me out there.
Yeah, we're heading down a slippery slope here, so if we are going to take that as a, where I can't find it anywhere here in the law that the person that puts out the job is responsible for it, I don't think you can point out the code section, but we are also now making every city, any portion of the state that puts out a project that has excavation, and every homeowner responsible ahead and with the contractor for a violation for not calling in the USA. And I don't think that's the intent of 4216 anywhere in here. It's the excavator that has the responsibility of calling and not hitting the utilities and not damaging them and proving them ahead of time, not the general contractor, the homeowner, the state, or the city.
Council Harrington, may I ask a question? Is there anywhere that on 4216 where it addresses anything about who should be accountable, or I just want to make sure, confirm. While she looks into that, is there any other comments from the board?
In the meantime, yeah, Member Johns, I do believe the excavator is what the law intends, to know what's going on, who's really putting the shovel in the ground or doing the work, regardless of the contractual arrangement, that the excavator is responsible for pulling the ticket, know what's going on. And like Member Bianchini says, it is a slippery slope and confusing, but ultimately it comes down to that person who's doing the work.
Member Charlene, so I see that also. I see Sun Country and all generals have the ability to call in a ticket. You know, they might do that for different reasons to cover their area, but requiring them to do it, if they're not digging, I would agree that's not in there. Custom Canopies was required to call per our law, and I feel they're responsible to have a ticket. But Sun Country could, but didn't have to have.
So then let's go to the discussion on the other two, which is when...
Let's stay on the one.
No, the other two elements. So if they're not responsible for 4216 2B, then are they responsible for 4216 4C1, which says that they have, if their subcontractor tells them they had a dig-in, are they responsible to report? And if so, if that's supposed to be in 48 hours?
Member Munoz, I'd like to refrain from moving, because we're going to dig deep on those other two, so we can, just to keep it organized.
We're just doing one at a time?
We're doing one at a time.
Okay.
Thank you.
So Member Voss here again. So just to be clear, Ron and Randy, in this case, Sun Country Systems, in your mind, would have no responsibility for any of these actions because they weren't the actual excavator. And we haven't discussed Custom Canopies yet, but I'm thinking when we get to them, it would all fall on them. Is that how you guys are interpreting it?
That's correct.
So I have a question for those of you that deal with the contracts in place. Is it clearly written in these contracts when working with subcontractors, the general contractor to the subcontractor, that they are responsible for that? It's just a curiosity question.
Member Munoz, I don't think it matters. As soon as whoever breaks the plane of the earth, they're responsible for compliance for 4216.
It's just a general question.
Yeah. But it does, but in their contract, it does say their contract with the excavator themselves, they say that they have to call Dig Alert, like very clearly. So obviously we're getting ahead of ourselves, but excavators for sure at fault, but we're trying to figure out what responsibility the main contractor has.
Remember, Charlotte, and I think it comes down to when we get, you know, as locators get these tickets, there are some subcontractors that do call in tickets, and they are doing jobs. Maybe they're doing cleanup. Maybe they're putting in some barrier fences, just doing some various things. They need to have a ticket because they are digging. But all the subs that they hire, they're required to have their own ticket in their own name for what they are doing. And in this case, from what I see, they were not digging. You know, they might have liked to have one, or they might do it for other reasons, but it's not required. Like I said, the one-call centers will take a ticket from them.
Counsel, you ready? Thank you.
4216.2. Sorry. Refers to the excavator. And so, looking at the excavator, you're back up. I'm just going to read to you what the definitions are.
Would you mind having the microphone a little closer to you?
Mm-hmm.
Thank you.
There we go. Okay, so can you hear me?
Perfect now.
All right.
Thank you.
Definition of an excavator. Any person, firm, contractor, or subcontractor, owner, operator, utility, association, corporation, partnership, business trust, public agency, or other entity that with their own employees or equipment performs any excavation. So if your law is for an excavator and your person fits within this definition, then they are an excavator pursuant to the law. I'm
understood. Thank you. Any other comments from the board?
Member Bianchini, I think the key to that was their own employees and their own equipment.
Thank you. We will now move to deliberation of the second proposed violation, Government Code 4216.4C1, failure to inform operators of facility damage. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin the deliberation.
Member Bianchini, I think again here it warrants just reading it. 4216 4C1, an excavator discovering or causing damage to a subsurface installation, including breaks, nicks, leaks, dents, grooves, and stuff, has the obligation to call the one-call center. And that, again, the definition of excavator.
Thank you. Any other member comments specifically to this violation? We now move to deliberation of the third proposed violation, Government Code 4216.4C3, failure to notify the one-call center of a damage within 48 hours. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin.
Member Voss here, again, since they weren't the excavator, they wouldn't have the responsibilities, I think, where we're interpreting this.
Mm-hmm. I agree with you, Mr. Voss, especially after our discussion. I also believe there was no violation.
So in summing this up in regards to Sun Country Systems, we would not find them in violation of Government Code 4216.2B for failure to notify one-call center of planned excavation, and Government 4216.4C1 for failure to inform operator facility damage, and Government Code 4216.4C3 for failure to notify the one-call center of damage within 48 hours because it did not meet the definition of being an excavator. Does that kind of sum it up?
Yep, that was perfect.
If you just could have put motion in front of that, that would have been great.
You want me to do that too?
We don't need a motion for this. As we see no violation, there's no need for us to discuss sanctions. As we see no violation, I do not need a motion. We can move on to the next item.
Oh, I was waiting for that.
You were ready for it, I could see.
Well, Member Johns here, I do think it's just an opportunity to say that you can see the confusion that occurs with subcontractors and who's responsible. The law clearly says it's the excavator, but the communication is important. So the message is that we need to communicate. You can't just rely on your subs knowing. So it's getting the message to the people, but ultimately the responsible person is that guy who sees it, who's doing the work, make sure he has a ticket, she, and then make sure that if they do damage it, they're at the site to see it and respond. So, yeah, I agree that it's clear that they weren't in violation as the excavator.
Thank you, Member Johns. The next item before us is an action item on the decision on NOPV to Custom Canopies, Inc., Investigation 21 LA 01483. Does any member need to excuse themselves from consideration of this item? Member Johnson continues to be excused. Seeing no recusals, we will proceed. The notice cited Custom Canopies for 3 violations. Government Code 4216.2B, failure to notify the one call center before excavating. 2, Government Code 4216.4C1, failure to inform the operator of facility damage. And 3, Government Code 4216.4C3, failure to notify the one call center of a damage within 48 hours. The NOPV proposes that Custom Canopies be required to take our education course. Custom Canopies has responded to the NOPV and reserves the right to contest a violation with the enforcement agency. Custom Canopies is under the enforcement jurisdiction of the Contractor State License Board. We will begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone. For those on the webinar, press the raise hand button or #2. We will start with in-person comments. See no in-person comments, we will move to webinar comments. Host, are there any webinar comments?
No hands raised.
Seeing no comments, we will proceed. We will turn now to the members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we'll then determine if the proposed sanction is appropriate. I ask that we deliberate on each proposed violation separately. First, Government Code 4216.3B, failure to notify the one call center before excavating. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin?
Member Munoz, I think we kind of covered in the last one, but I think that Custom Canopies is in violation of 4216.2B. And it's based on everything in here. There's no ticket, and then the resulting dig-in.
Thank you. Any other board comments?
Yeah, Member Bianchini, I'm just reading through, and I thought I had it, but I don't. So they reserve the right to contest violation with the enforcement agency, which is us, and I don't see any contesting. There's no
copy of the.
Well, I don't have a copy of it if there is one.
Board Member Charlotte, are they referring to our result they could contest? We are to discuss it. We are to determine fault and what the violation is, and then they have the ability to contest it.
Counsel, can you help us with that? I don't see a copy of it. Who's the investigator on it? Mr. Corsi.
So, you need just a response, what it says?
So, it appears that when we read through the document that's provided to the defendant, right? It appears that by them checking the box that if they disagree with the penalty that's imposed, they will have the right to contest it.
Mr. Corsi, as the investigator on this, is there anything that we missed, or did you get?
If I'm correct, I believe that their response said that they reserve the right to have it heard by their regulator,
Okay.
and that would be the CSLB.
The CSLB?
Yes.
Understood. Are we good with that? Do you, Mr. Charlin, or Bianchini? My apologies.
Member Bianchini, they checked the box that says you're contesting the violation, the penalty, or both. So I think we should just proceed on whether he violated and hand down whatever we're going to hand down, and then let him make some sort of a plea to the state license board.
Member Munoz, and then it continues on to say that they don't wish to present their comments to us. So you're right.
They're going to address it with CSLB. Any further comments? Proceed. You good? Yeah, we're good. Did you, go ahead, counsel.
I was just going to make it official, yes.
Okay.
They would be contesting whatever decision you make, so go forth.
Thank you. We now move to deliberation of the third proposed violation, Government Code 42164C3. Failure to notify the one call center of a damage within 48 hours. Please state whether you agree with the violation occurred. In doing so, please list the facts that you relied upon. Members who would like to begin the deliberation?
Member Bianchini, I agree with the violation. There's no evidence of a ticket that was called in, and they don't also provide one.
Member Munoz, I agree, and it looked like they called the irrigation services instead of the call center to report it.
Member Voss, I concur that they violated all three government codes, 4216.2B for failure to notify one call center of a planned excavation, Government Code 4216.4C1 for failure to inform operator facility damage, and Government Code 4216.4C3 for failure to notify the one call center of damage within 48 hours.
Then we'll go ahead and jump straight to that. A little bit. That's okay. I think we're all in agreement with this. At this point, I will entertain a motion for the board to take action on this item.
Member Voss, I move to find that Custom Canopies, Inc. violated Government Code Sections 4216.2B, 4216.4C1, and 4216.4C3, and would benefit by taking the board's education course.
A motion was made by Member Voss. Second?
In a second, by Member Bianchini, I would like to add an additional fine for the arrogance that he's going to go to the board and not listen to this board, or take the safety, which he could have done out, and therefore for wasting this board and that board's time, I think he should pay a fine of about $2,500.
Member Bianchini, I personally don't agree with that. I think the education is good. That sounds like an emotional response.
Okay. I have no emotion in it whatsoever, other than the fact that they are telling you, Madam Chair, and the rest of the board members that whatever we deliberate here and spend time with Chief Corsi and everybody else is irrelevant. He's going to talk to the CBL. And so we can only pass on what we think it should.
Mm-hmm.
So that's all I'm asking to do, is just we think that he should take our safety course and pay a fine. No emotion.
Is there any other board member that agrees with that? We would have to.
Member Sharp.
Go ahead.
Member Munoz, can we table the motion then really quick so we can have that discussion?
We're tabling it at this point. We're furthering the discussion. So Member Charlin?
Yeah, I'm opposed to the fine. I think when we're going through these, everybody, including us, is trying to figure out how to comply with this. There's terminology we don't understand. There's different options that they have, and they probably don't understand what each one of these actually means. And I'm going to give them the benefit of the doubt. They might think, maybe talking to their lawyer, that that's the one to pick, and they were kind of forced into, okay, let's put that one. It gives us a second chance to argue it. At some point, I probably would agree, once this has kind of worked itself out, we will know that, hey, people are going around us, and we know that's for a fact. I don't know if we know that right now. Of all these categories they get to pick, and I think we need to start with education and kind of get through some of these things to see if there's a pattern, or see if there's, a lot of these are starting to all go to a different avenue than through us. Then I would be more open to that.
And I believe they're still in their jurisdiction to have the decision to address this differently.
Member Voss here, just wanted to comment. So, just to be clear, we give them the form and the choices that they have to make. They just choose to check off the box that they reserve the right to contest violation enforcement. I don't think that says they're going to. It just says that they reserve the right, and they also are clear that they're not going to necessarily present comments. So nothing may ever come of this. So I think, in fairness to how we've approached everything to date, let's get you educated this first time. You do it again, they're going to get spanked. And so that's all I got to say.
Thank you, Member Ross.
Member Johns, I concur with what Member Charlin says about the process and allowing some grace here to allow them to go through the process. But I do believe we are approaching the time where they've been in business. They should have a contractor license since 2006. Ignorance isn't going to be accepted. That's the purpose of our board. What the purpose of putting some teeth in the law to say that you don't call, you're in violation. If you damage something and you don't report it, you're in serious violation. So this is, to me, it's a major violation, but I guess I'm still at that point saying, okay, I'm definitely education is required, but I think we need to start giving the message back that this isn't acceptable. So moving forward, I would probably be siding more with Member Bianchini.
Member Munoz, I just want to go back to 4216-19E and 19 CCR 4201. It says the type of violation, its gravity, the degree of culpability, the operator's or excavator's history of violations, the operator-excavator's history of work conducted without violations, and the efforts taken by the violator to prevent violation, and once the violation occurred, the efforts taken to mitigate the safety consequences of violation. So for 5 would be the only reason I would see item 5 of the reason of what we're supposed to rule, or how we're supposed to set those standards for sanctions. I would see a financial penalty based on the fact that after the event they still did not call 811. I wouldn't say for how they chose, to respond to us. I would say that it was still very, they still didn't follow the law. They didn't report it like they should have. So that would be the only reason, but I would see financial. But I'm okay with just education for this one because we have set precedent for some that even included death of not putting them under financial penalty. And if we're looking at number 1, the type and violation of its gravity, that this is water. I mean, not as grave as it could have been. But I think just the education alone, and if they're listening to us, this could have been a lot worse. It could have been a lot worse. It could have been a gas line. It could have been an electrical line. Somebody could have not gone home. And I think sometimes we forget that. I mean, just like Member Charlin said, we go through all of the laws, but the intent is to protect the public, and this is at a school site. So this could have been really bad. So we just need to keep that in the forefront, the safety element.
Thank you for the discussion. Council, we'll just go straight into repeating the motion.
Yes, you can do that. I just would like to remind you that You can only enforce what's in regulation and statute and how people choose to mark their responses. Even if they ask for a hearing and then totally blow off the hearing, you cannot give them a fine for that.
Understood.
And yes, I would, you could either just take up your motion again as it stands or make a new motion, whichever.
Mr. Voss, would you mind repeating the motion?
Member Voss, I will restate the motion. I move to find that Custom Canopies, Inc. violated Government Code Sections 4216.2B, 4216.4C1, and 4216.4C3, and would benefit by taking the board's education course.
Thank you. May I get a second?
Member Bianchini, I'll second that.
Thank you, Member Bianchini. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini,
Yes.
Charlotte,
Yes.
Del Toro,
Yes.
Johns,
Yes.
Munoz,
Yes.
Voss.
Yes.
Motion is adopted. Is the board okay to continue on? Would you like to take a 15-minute break?
We're almost done.
We're almost done. We're good. The next item before us is an action item on the decision on City of Azusa Light and Water Department. Investigation 21LA01483. Does any member need to excuse themselves from considering City of Azusa? I believe we should have Mr. Johnson or Member Johnson. Any other member? See no recusal, we will proceed. The notice cited City of Azusa Light and Water Department for violating Government Code 4216.3A1A, failure to respond to excavators by legal start date and time. The NOPD proposes that City of Azusa Light and Water Department be required to take our education course. The City of Azusa Light and Water Department was provided a written response to explain why the city is not in violation. The City of Azusa Light and Water Department is under the City of Azusa's Utility Board's enforcement jurisdiction. Our decision is whether to make a recommendation to the City of Azusa Utility Board. We'll begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone. For those on the webinar, press the raise hand button or #2. We will start with in-person comment. Seeing no in-person comments, we'll move to the webinar comments. Host, are there any webinar comments?
No hands raised.
Seeing no comments, we will proceed. We will turn now to the members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we will then determine if the proposed sanction is appropriate. I ask that we deliberate on the proposed violation of Government Code 4216.3A1A. Failure to respond to excavator by legal start date and time. Please state whether you agree with the violation, that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin.
So Member Johns here, I didn't follow the violation versus their response. They said the area was outside their jurisdiction. Yeah, could I ask?
Mr. Corsi?
Yes, their response was that the ticket notification area was outside of their service district as a water district. And I responded to them. I spoke to the manager, the city manager, and I let them know that you have to respond. The law indicates you have to respond anyway, and that if they needed to contact the one call center to draft their shape files. So it would make sure they wouldn't get notifications which were outside of their service district anymore. But even though it was outside of their service district, it's still a requirement that you have to respond, and you could respond no conflict, but you have to respond.
Thank you. So yeah, not having, I guess their shape files are in error and cause that. It does still is a problem for the contractor. And,
correct.
Yeah, so I'm kind of curious to know the problem, and it must be common. We find in the industry, but if seems if their shape files show it, they need to respond to it if they get the notification. So,
Member Charlin, so it might not be a problem with the shape files. I don't think anybody can get exactly where their facilities are. So a lot of people put a buffer on, and then I believe the one call centers put a buffer on. So you start getting these buffers where they go farther, because it's better to over-notify than under-notify, correct?
Mm-hmm.
So in this case, even though they didn't have any facilities there, that was a new ticket, I believe they had a responsibility to say to the caller and say, hey, we don't have anything there. Just like some of the long-distance callers do all the time, because they have one single line, but they have a big buffer. They constantly have to do that, to clear it and say, hey, we have nothing there, even though we're a city over. So it's their option. They can look at it and say, hey, we don't want to do this much EPR of over notification. Let's thin that down. They have that option to do that. But in most cases, I think you're going to have some type of buffer. You're never going to get exactly where your line is.
Member Munoz, I agree with that, and I think that's one of the discussion points we've had when it comes to the continuous excavation. There's so much of a buffer that everything's on there. So I guess my question and my concern really was, whose water was it then? So if it's not theirs and they didn't respond at all, if it's somebody else's water, how are they ever going to get their water shut off on that? It's just, it has nothing to do with the violation per se, but for a safety aspect, who is responsible for that? Did you get that out of them?
Your mic's off.
Sorry about that. I was the city of Glendora, which is the next city over.
So did City of Glendora get the notification as well, or no?
No, and that was the issue. So it's going to have to be adjusted. Their shape files are going to have to be adjusted.
Member Voss, so I've seen this personally with the company I work with. We have registered facilities with the call center, and they need to be reviewed because over time they've gotten tweaked and things gotten out of shape. So this appears to could be part of that example where clearly they get notified and they say, well, that address isn't ours, but you got to put the responsibility on someone to go clean it up, and call center is not going to know one way or the other. So it's and I take it, Mr. Corsi, this came up because you're reviewing the ticket and they saw the no response. Is that correct?
Correct.
Yeah. So I was gonna make a comment later, but one of the things about not all these cases, and particularly the next one we're going to hit, is there's so many moving parts to these things. It's making it very difficult to review. So a good point that this is just the fallout of our investigator reviewing the case, and there's nothing wrong with him picking up on that. That's what you're going to do.
Mm-hmm.
So I just food for thought.
Member Munoz, so then I guess we need to discuss if the electronic positive response is required and they receive the notification, is it their job to respond, or how would anybody know that they don't have facilities there? And how would there ever be any incentive to clean up the maps?
Member Charlin, yeah, and I believe it's in our law that says they get a list of all the members that got notified. They cannot dig until they get some kind of notification from each one of those. Because again, like you say, they might know there's water there, but they don't know if it's Glendora water, Azusa water, or LA County water, or LA City, you know what I mean? You can start getting into these things. And this happens all the time with telephone companies. They'll cross over and be right next to someone. So there will be two, and it's very common to have two power companies, two telephone companies on a ticket. And the excavator doesn't know. That's why he's calling in and saying, hey, he's looking for clearance, that they don't have anything. So I think education would be beneficial to say, hey, all these tickets you're getting, you do have to give a positive notification, which I'm pretty sure they don't understand at this point right now. That might cause them to look at their mapping and reduce it so they don't have that burden, right? If they're able to do that and say, hey, we're willing to accept this side of the street, but we have it turned on so much, we're actually getting a mile into these other cities. We probably want to, clean that up and get that smaller.
Yeah, and Member Johns, I agree, there are those overlap areas, but it's a shared responsibility. So if you have a utility or whatever, and you got to be part of the system, and you have to do your maps and everything like that. But it's your responsibility to clean it up and do that, not the contractor who's out there hung out to dry waiting. And so it's I guess the recourse is to get their maps and their shapes down to minimize them. But yeah, he's got a responsibility here.
Member Bianchini, I agree with Member Charlene and Munoz that if he would have responded instead of taking the approach that his letter does, it might have been the one call center to try to figure out if there was another water agency that did have an overlap, and this contractor then would have known that the water belonged to somebody else instead of finding it the hard way.
Member Munoz, I would say, Chief Corsi, we need to investigate City of Glendora as well. If that can be an action out of this investigation to see why they're not supplying their maps correctly, which is the same responsibility we're asking this water district to take. So I guess if we're I want to keep on my schedule here with my Madam Chair. I'm going to say they are in violation of the first of 4216(3)(a)(1)(a), and I'm in agreement with all this discussion.
Member Voss, yeah, I think at the end of the day, the operator's got to take some responsibility to, if it's not theirs, they need to make an effort to clean it up in the system so it doesn't continue to be an error. And I think positive response, this is an example where the positive response is going to make that stuff surface probably from time in and time out. But I don't know who else to put. The only one you can put the responsibility on is the city at the end of the day.
So just my question, so are we saying now that the cities are responsible for others' jurisdiction? Is that what we're talking about?
No, Member Bianchini, no, I don't believe so. I believe that when they are indicated on a ticket and they don't have anything in that area, it's their responsibility to say to the ticket that they have nothing in that area. And then the contractor would go back to the 811 service and say, I have water lines out here, I see hydrants, I have detector checks, and I'm being told by this water district they have nothing in that area.
Any other board comments? Now that we have discussed the violation, we may now proceed to discuss the proposed sanction. The NLPV proposes a sanction of mandatory completion of the board's education course. I ask that we deliberate on the proposed sanction. For those of you who find that a violation did occur, please state whether you agree with the proposed sanction. In doing so, please list the provisions of Section 4201 of Title 19 of the California Code of Regulations that you are using as the basis of your determination and facts you relied upon. Members who would like to continue the deliberation.
Member Bianchini, I agree with the proposed safety course, having them take it due to the fact that they did not create a positive response as required by 4216, and that they could benefit by taking the board's safety program.
Are there any additional considerations for the record that a member would like to make before I ask for a motion? Seeing no further deliberation, we'll proceed to a motion. I will entertain a motion from the board to take action on this item.
Member Voss here, I move to find that the City of Azusa Light and Water violated Government Code 4216.3 A1A and would benefit by taking the board's education course.
A second?
Member Bianchini, I'll second.
A motion was made by Member Voss, a second by Member Bianchini. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini,
Yes.
Charlotte,
Yes.
Del Toro,
Yes.
Johns,
Yes.
Munoz,
Yes.
Voss.
Yes.
Motion is adopted. If the board doesn't mind, I'd like to take a 10-minute break. Are we okay?
I'm in agreement.
Okay, thank you. We'll resume back at, oh my gosh, math, 3:18. Is that right?
308.
3:08. I don't do my financials in my business. Thank you. Ready?
Yeah. I feel late. Where's your gavel?
At my office, I keep forgetting.
We're ready when you are, Ms. Chair.
The recess is ended. The meeting will return to order. The next item before us is an action item on the decision on NOPV to Frontier Communications Investigations 22 LA 01484. Does any member need to excuse themselves for considering Frontier Communications?
Member Charlin, I need to recluse myself.
Thank you. Please exit the room and we'll invite you back after action has been taken on these items. The notice cited Frontier Communications for two violations. One, Government Code 4216.3A1A, failure to respond to excavators by legal start date and time, and Government Code 4216.3C1A, failure to provide timely electronic positive response. The NOPV proposes a financial penalty, the amount of which is to be determined by the board. Frontier has responded to the NOPV requesting the board does not issue a financial penalty. Hold on, my apologies. Bear with me. Issue financial penalties or alternatively issue a penalty not to exceed $1,000. Frontier is under the board's enforcement jurisdiction. Well, we begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone. For those on the webinar, press the raise hand button or #2 to enter the query. We will start with in-person comments. Seeing no in-person comments, we will move to webinar comments. Host, are there any webinar comments?
No hands raised.
Seeing no comments, we will proceed. We will turn now to members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we will then determine if the proposed sanction is appropriate. I ask that we deliberate on each proposed violation separately. First, Government Code 4216.3A1A, failure to respond to excavator by legal start date and time. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin the deliberation.
Member Munoz, this one is very convoluted, and a couple things. So first of all, they didn't respond in a timely fashion. They also, on January 21st and other times, they said that they saw that there was still something that needed to be marked, but the electronic a positive response was transmitted to him by DigAlert automated email, and what they said is that they had already marked. So it's like so misleading, and this went on for weeks and weeks. They didn't respond on time. They couldn't locate it. There was a failure to mark because they were unable to locate the fiber optic line. And then when Utiliquest was trying to work in partnership with Mr. Johnson with Frontier, they reached out directly to Frontier, Mr. Ling, and there was a failure to respond there, even directly. So this went on from the original time of start, like almost a month. This is very excessive. And so if we're using the original thing of what actions were taken to mitigate the problem after there was a problem, there was no response. So I'm going to say they are definitely in violation, and to the point where it's almost ridiculous how long this took to resolve. And how much did that cost the excavator? And I would like to really acknowledge Merlin Johnson Construction, because they were very patient through this entire process. They went so far as to have a map, to ask for a field meet so that they could go over everywhere that they were going to do the work. It's actually, this is a really good process that this person tried to follow, but I would say Frontier did not help in the least.
Member Bianchini, I couldn't have said that better myself, Member Munoz. But if you'll all pardon my redundancy, I just need to put this on the record each time. And for the benefit of Marlon Johnson, who was extremely patient, you didn't need to go through all the hoops that you unfortunately had to. Those codes that are being tossed to you are strictly for operators to communicate to operators. They have nothing to do with anything in 4216, and they're not sanctioned by it, and it is not a response. So when you get those, the immediate thing to do is to say non-responsive. Most excavators do, and I hope you're listening.
Member Voss, so Ron, I need some clarification there. So the non-response call from the contract excavator Johnson is not a sanctioned code? Say that again? No. So what a lot of locators try to do to buy additional time is they'll use a set of codes that they made up that are strictly through the one call centers, and they're not in 4216. It is not a proper response. It's not a response that's recognized by the law, but that 080 extreme weather, it's not recognized. I mean, if you want, get it in there, put a bill together and do it, but it's not. So we get those continuously, probably 4 or 5 different jobs a week get these codes that are just redundant, and that's an extreme weather one. And extreme weather has nothing to do with COVID, which they try to say that it is. The proper thing that they can do is call and ask for a field meet and say, I can't get to it until X. And if that's acceptable, it's acceptable to an excavator. Now you have an agreement. But all those codes, zero, no, non-response. If it goes past the 48 hours that they had and they're just put codes on that ticket, that's a non-response. So another question. So I look at the report here and look at page 7, where it has the table, if I'm reading this correctly, it looks like all the parties responded in time, identifying there was going to be a new marking schedule based on the way it's summarized in the table. Did any of you get that out of that?
I think Merlin Johnson agreed to put together a field meet where everyone can get together and look at it. I think he said it was like 200 acres or 20 acres of
20 acres.
20 acres of area that was in the zone. So he wanted to go over that. So that's kind of slightly different. But I think what Member Bianchini is referring to is that even up until January 21st, Frontier actually had an electronic positive response saying that they had marked everything, and they didn't. And, I mean, it goes on to say that, you know, they thought they fixed the tracer wire, they thought they did this, they thought they did that, and they're using electronic positive response as a way to say that they've done their job, but they haven't, to be misleading. But what Member Bianchini is saying is, until you actually do it, all of the response is just a communication method, not necessarily a requirement.
Okay, so, but is the no response generated because no one physically showed, no one met together on Monday? Because it looks, based on the table presented, if it's correct and ties back to the tickets, that everybody responded, that they were going to have even though the excavation date, I think, was Friday after 5 o'clock, according to the table here, it says that they responded, that they were all going to meet on Monday the 10th.
Oh, I see what you're saying. So he's saying that there was no response on, I think it's the 13th, 14th, 17th, 18th, 19th.
As it relates to Frontier?
As it relates to them.
Yeah. So, Ron, a question for you. When I'm looking at the page 3 here, it has, it refers to the same ticket number, and it says, type NRSP. What does that stand for? No response?
I don't have. What page are you looking at?
I don't seem to have that. Yeah.
You want to?
Which one? I think the ticket number says, type NRSP.
The summary. It's a summary in the report.
No response.
No response. SP.
No response, right?
Yeah. Yeah, so it's response is what SP stands for. Or SP.
And obviously, looking at the same table down the way, when we get to 131, there's something that says renew, and then looks like on 2-3 a remark. So what I'm trying to separate here is you indicated Mr. Johnson he was patient, but then it looks like he was pushing the button a lot that there was no response.
So I think the reason why I was pushing that button so much is because he went above and beyond and tried to give them a field meet. And then, so now we're looking at, they promised by the 11th, and then it goes on. He pushes the button, like you say, no response on the 13th, 14th, 17th, 18th, and then he calls and makes a complaint to the board, and the 19th, and then it goes on, and then on the 21st, they say that Frontier says they've already done everything, everything's done. But on the 27th, they're still talking about putting in tracer wire, and they're still saying they are not doing it. So I can't believe he's so patient, because every single day he's not able to do his work is money lost. So to me, this is shocking that he waited so patiently. And I think the amount of time he waited is irrelevant. It's just that they didn't comply.
It's really unfair to these excavators.
But I want to be clear that the problem came after the initial request. It was compounded, and then they looked like they lied.
I think it was ongoing.
Yeah, it was ongoing.
Yeah.
So I don't think there's in my mind, there's no question that all these were, when we get done, we're probably in violation. I'm just, it all, because everything is run together and one with all the other entities there, I'm trying to make sure we're clear on who did what at what, at least here in the beginning.
Member Johns, can I ask Inspector Corsi input on, because I'm confused on the Frontiers. They asked for a field meet, and then he had partially marked the site, it says, and then doesn't sound, did the contractor show up for the field meet, or I think he's scheduled for the 10th or something like that?
The investigator was Executive Officer Marino, I think, on this case.
Oh.
So if I'm picking up where you're asking, the excavator on the ticket indicate meet at mark. The Frontier had a locator who was there on that day, but not during the meet and mark, but not during that period where the excavator was there. Frontier did respond in their, I'm not going to speak for what is in Frontier's letter because I do get confused between some of the other responses and I don't have that in front of me. So yes, there was a locator on site that day, and Johnson indicated that it was, that the contact with there was a locator on site that day, and Johnson indicated that the locator was not there when he was there, but that he got contacted by the locator after that period.
So he did respond by at least setting up a field meeting and came back to meet? Or I guess it looks as though he partially marked and then he left, but that was his attempt to come back and have a meeting. I didn't quite follow it in how the write-up stated.
The operator, the locator, and the excavator had a discussion. I believe it was 10:11 a.m. on that Monday, and there was a discussion about future locating that needed to still be done. I won't speak to what constitutes a response, though. I'll let that be up to you guys.
And then kind of follow-up to that was at the end of it, the report, it said that Frontier had issued a clear, but then said that it was incorrect and they retracted that, or how did that come about?
Member Bianchini, as I recall, what it was is they issued a clear and then said that they still had to go out there and meet, wanted a field meet. They missed their times on the field meet, and at the same time, the contractor, excavator, put in a no mark service to it, which generated another ticket.
No response again.
No response went in. He dropped that ticket thinking it was a mistake. Instead, it was a no response to him not responding because he threw those other codes in there. And that's where the confusion became the deepest between the operator and the excavator.
In Frontier's words, it fell between the cracks.
So was Utiliquest actually marking for 3 of these operators?
That's my understanding, yeah.
Okay. So the same fellow that was with Utiliquest was probably ultimately going to mark for all 3.
It could have been multiple people. I mean, we have all these same issues in Northern California.
Got it.
So I guess going back
to this no response thing, so what does this mean? So Johnson sends out a no response, but you say it has no bearing or merit? They don't have to respond to it?
No. What I said was when they responded with
no conflict,
a code, no, they didn't respond no conflict. They first responded they didn't have anything, and then there was no utilities. Then they did a 080, which is a extreme weather.
Well,
Member Munoz, Member Voss,
yes.
let me try to summarize it this way. So before they timed out and they would go exceed the time that they had to respond, instead of responding timely, they provide misleading information that said they didn't have anything there. And so let's say this excavator was not as diligent as this excavator apparently is. They could have just continued on their merry way, saying that they were done. There was no conflict there. They could move on with their lives. But apparently, this person really knew and continued to drive action to get all of these people to meet. And looking at this 20 acres, they were like, you know what, it's not enough just to say all of it, I want to have a field meet. Mm-hmm. They went above and beyond, and then they didn't show up for the field meet. And instead of saying, okay, we didn't mark everything, they marked all kinds of other misleading information, including, horrible weather or whatever that one, the 801 is, the one that's like act of God, basically. All the way through where they started to say they couldn't mark the last 30 feet because of tracer wire missing, but basically leading the excavator on a wild goose chase. And I think what Member Bianchini is saying is you're trying to put all these comments in there. Not necessarily the excavator. The excavator is saying that no one came. They call the call center back, or they go on the app and they say, this still hasn't been done. So they're telling everybody, hey, this has gone past the required response time. Nobody's come, so no response. That's not what Member Bianchini is talking about. He's talking about the owners of the utilities saying, oh, they can't come, or whatever they say doesn't really matter until they complete the task. Did I get that right, Member Bianchini?
Yeah, there's only two appropriate responses. Either we have no utilities in the area, or we have completed the markings.
Now, Member Johns, I have a question then, and I'd like to see Member Charland here to ask, but on the no response ticket, the guy said that, well, that was another ticket that created confusion. Isn't there a track that shows that that's a no response to the original ticket, or is, how was that confusion?
Yeah, there is, and it shouldn't be able to be killed by one party, but it was.
So, but it was a separate ticket? I mean, that's what he said.
It generates a follow-up ticket. There's no response because everyone else on that ticket had responded, but that. And so he was trying to say, okay, the rest of you guys are good. There's no response to Frontier.
Board members, we have two people from call centers. Maybe we can have one of them come up. Would that help answer? Do you need that?
Maybe so. Part of the question too is how the company responds to the ticket. If it recognizes, obviously, if the locator's sending out different people, then he might not know and lose it in just the quantity. But it seems like the ticket, and that is, I would like to understand it better, that
can we get a volunteer?
Yeah, is that okay to do?
Ms. Diamond? Thank you.
Yes.
Ann Diamond with Gigalert. I want to, before I answer any questions, I want to make sure I understand what you're asking, Mr. Johns.
Okay. In my write-up, it said that the Frontier had, there was confusion. He said he set up a meet, and then while he was doing that, another no response came in, and it was a different ticket, so he was confused. Now he thought it was a different ticket altogether. So I'm trying to understand, is that a legitimate thing that somebody could do?
Each time a ticket is sent out, if it's, as long as it's the same ticket number, it has different revisions. And no response does not require an electronic positive response. It can have one, because when we send out a no response, we send it out to all members on that ticket. And if they're only asking for Frontier, that means that Yucaipa Valley Water, Southern California Edison, everyone else would not have, they shouldn't have to respond. It like I say, it does require, it's an optional response, and they can send through something. The responses, the tickets that do have to have a response on them are new tickets, remarked tickets, and there's one more. And sorry, off the top of my head, I don't remember.
Renew? Renew?
No, renewals don't have to have a response.
Do you, a follow-up question then, do you think the confusion, is it a confusing process, you think?
We can't ask those questions, Member Jones.
Don't answer that.
Yeah, it's up to us to determine.
No, I don't. Me personally, I don't think that it's a confusing process.
I think council stopped that whole question.
Thank you. Thank you, Ms. Diamond. Appreciate it. So it sounds like we're all in agreement that there is a violation, correct? So we could just move this forward. So let's move on to violation 2. We turn now to the second proposed violation, Government Code 4216.3. C1A, failure to provide timely electronic positive response. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination.
Member Munoz, the violation definitely occurred. And I mean, it's all over this thing, but I do have a question, I guess, for E.D. Marino. I saw in here that you also list 19 CCR 4151, obstruction of an investigation. And in reading this, I absolutely agree. I just wonder, where do we have jurisdiction to enforce that, or is this going to be escalated? Because everything that you're saying, not only are they in violation of both, I can clearly see that they are misleading. Everyone's being led down the wrong path. We'll do it tomorrow. And how are we going to address that last concern on there?
So I identified it in the investigation, that as a violation. However, we did not identify that in the NOPV, and it is not before you as a violation for you to decide.
Do we have the ability to enforce this going forward? 19 CCR 4151?
In my opinion, we do. But that, of course, just depends on the set of facts.
So are we able to rule on the first two recommendations here and issue a notice of NOPV and come back to the third one at a later time? And the reason I'm asking is because this is absolutely leading, it's leading everybody on a goose chase. I think that this could have been a lot worse, this could have been really horrific had this excavator not had the patience, the due diligence, and overall just the stamina to do the right thing. I think any other excavator, this could have ended up really terribly. And I think if it's possible, I would really like to come back to that 19 CCR 4151 and issue an NOPV on that and come back to that.
So one thing to consider, it was identified in the investigation. It was not, however, provided to you as something we would like you to decide on as a violation in the NOPV. However, the NOPV does identify what staff believes to be considerations in which to assess sanctions and considerations on whether or not corrective action should be available. And that violation is what we were considering when we were identifying the ability for the respondent to get corrective action. And so that's kind of how we feel it should be, and that's what we have and provided to you.
So let's continue on 2. Any further discussion on the second proposed violation, 4216.3?
Member Vosser, just to be clear, so it alludes to this in the report, but it appears that is a proper response when you're into the process of marking, they don't have all the information. Would a proper electronic response could be partially marked, more time is needed? Is that a proper response? In the positive response world, if physically it's not marked and you need a response, is a partially marked, more time is needed, is that considered a response that could be accepted? I mean, that's a pretty practical response. It's not done yet, is what I'm getting at. And so, in our world, is that it may not have met the time criteria, but at least they're responding correctly that it's not done. And so I'm trying to clarify on some of these ability to respond back, what can be accepted as a responsible response is what I'm trying to get to.
So I'd like to, unless council or anybody wants to respond, but I'd like to bring it right back to this violation, because we can continue this discussion because there's a lot of questions, a pretty large case that we're dealing with right now, but let's stay focused, if I can bring it back on this. So bringing it back to failure to provide timely electronic positive response, do we believe that they did fail that? Sounds like we do, correct?
Thank you, Madam Chair.
Any other discussion on that particular violation? Okay, now that we have discussed the violation, we may now proceed to discuss the proposed sanction. The NOPV proposes a sanction of a financial penalty, the amount of which is to be determined by the board. For those of you who find that the violation did occur, please state whether you agree with the proposed sanction. In doing so, please list the provisions of Section 4201, Title 19 of the California Code of Regulations that you're using as the basis of your determination and facts you relied upon. Please also state that we believe to be the appropriate sanction. Please also state what you believe to be the appropriate sanction level. Members who would like to continue this deliberation.
Member Munoz, I think that the education is one aspect, but to what I was pointing out earlier, this 19 CCR 4151 and everything else that we already agree that they are in violation of, the obstruction of an investigation is really evident. It's in the timeline. I would propose we hit them with a $5,000 fine in addition to the education, so that going forward, they don't misrepresent their intent to mark. And to Member Voss's point, they didn't partially mark do any markings. They just used that as a way to try to pretend that they had complied. They said they didn't have anything there as a way to say that they had complied. They said there was an act of God as a way to say that they had complied. So I think there was, Frontier never responded to the questions. I feel that $5,000, given the fact that if I'm looking at these again, the type of violation and its gravity, not only did they violate, they continued to violate repeatedly throughout the whole time with misinformation. If I look at the degree of culpability, they were extremely culpable, but they wouldn't take any ownership or even participate in this investigation or in responding to the excavator, even though the excavator was extremely patient. Then I would say the number 5, which is the efforts taken by the violator to prevent violation, and once the violation occurred, the efforts taken to mitigate the safety, the consequences, they didn't do any of those things. So I think $5,000 is appropriate.
Board members, any discussion on that?
Member Voss here, of course, kind of ironic in their response letter from through Mike Jesse, Director of Operations, they plead that the fine not be more than $1,000. I kind of had some mixed feelings on that myself, because I think the way this thing drug out all the way as long as it did, I think they definitely were trying to hide the ball and not just be upfront of what their issues were. I don't know whether 5,000 is the right number, but I'd like to hear from my other board members.
I'm in agreement with Member Munoz with everything she said. There needs to be a fine. This is serious. To me, it's pretty serious when you're trying to hide things, for lack of better words. But I believe with the $5,000 penalty is appropriate.
Member Bianchini, I can agree to that. In addition to, I'm sure that the contractor excavator has a lot of standby and everything that he should be following up on as well. I mean, that's one way that most contractors do fight these things is like, look, every time you give me one of these answers, no, it's a no mark, and my crews cost X amount per day.
So, Member Johns, yeah, this certainly was a convoluted case, and I do agree that the contractor deserves a better response than at least what I've seen here on paper. So I do agree that it's beyond just education in this case, and I don't know, I can't argue with your suggested amount, so I'm in agreement with the group.
Thank you. Are there any additional considerations for the record that you'd like to make before the motion?
Member Voss, I'll make the motion.
I'm not.
Oh, you're not asking for it yet?
You're so good at those, though.
I got to turn these hearing aids up.
See, no further deliberation. We'll proceed to a motion. I will entertain a motion from the board to take action on this item.
Okay, Member Voss here. I move to find that Frontier violated government codes 4216.3A1A, 4216.3C 1A, and 19 Code of California Regulations 4151C. The board recommends that Frontier be imposed a financial penalty of $5,000 to their governing body for lack of cooperation with the excavator and the investigation. We also would like them to take the board's education course.
A second?
I second. I second.
A motion was made by Member Voss. A second was made by Member Munoz. Please vote by stating yes, no, or abstain when your name is called. Secretary, please take roll call.
Bianchini?
Yes.
Del Toro?
Yes.
Johns?
Yes.
Munoz?
Yes.
Voss?
Yes.
Motion is adopted. How are we doing? Good. Okay. The next item before us is an action item of decision on NOPV to Valley Water District Investigation 22 LA 01484. Members Charlene and Johnson have recused themselves. Does any other member need to excuse themselves from considering Yucaipa? Sorry, Yucaipa. I can't say it. Yucaipa Valley Water District. Thank you. See no other recusal, we'll proceed. The notice cited Yucaipa Valley Water District for violating Government Code 4216.3A1A, failure to respond to the excavator by legal start date and time. The NOPV proposes that the Valley Water District be required to take our education course. Yucaipa Valley Water District has responded to the NOPV and does not contest the violation, but does contest the penalty. Yucaipa Valley Water District requested an informal hearing before the Underground Safety Board today. Yucaipa Valley Water District is under the enforcement jurisdiction of the Yucaipa Valley Water District Board of Directors. Our decision is whether to make a recommendation to the Yucaipa Valley Water District Board of Directors. We will begin by taking public comment on this item. After that, we will invite staff in Yucaipa Valley Water District to an informal hearing. If any member of the public would like to make a comment, please come to the microphone. For those on the webinar, press the raise hand button or #2 to enter the query. We will start with in-person comments. See no in-person comments. We will move to webinar comments. Host, are there any webinar comments?
No hands raised.
Thank you for your, seeing no comments, we will proceed. Yucaipa Valley Water District has requested an informal hearing. Is there a representative from Yucaipa Valley Water District here today? Host, is there a Yucaipa Valley Water District representative present or on the phone or webinar?
I'm sorry, would you repeat that?
Do we have a representative from Yucaipa online or phone?
Not that I see. Can you maybe say the last four of the phone?
Is there a Yucaipa Valley Water District representative present on the phone or webinar? Please raise your hand or use the hand button.
You can press #2 to raise your hand.
#2. Thank you.
No, I don't see one.
Okay, thank you. We will turn now to members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we'll then determine if the proposed sanction is appropriate. I ask that we deliberate on the proposed violation of Government Code 4216.3A1A, failure to respond to excavator by legal start date and time. Please state whether you agree with that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin the deliberation.
Member Bianchini, in reading Yucaipa Valley Water District's letter and their proactive remediation approach to it, they admit that it did. They are putting in steps to make sure that it doesn't again. They've suggested names of their own group to take part in the board's educational program. So therefore, I believe that the violation did occur, and that because they're taking a proactive approach to it, I really appreciate them.
Member Munoz, yes, I think this letter is beautifully written. They agree that they don't contest it. They agree they're in violation, and this is just an excellent example of how to improve an entire workforce and to lead by example. They went and did all the research. I'm sure they picked 4 people, but I'm sure they're going to cross-train everybody. So I think this is great.
I also agree with the letter was well written. It was refreshing to hear accountability.
Member Voss, I appreciate their letter and also the fact that they recognize their shape files need to be updated.
Now that we have discussed the violation, we may now proceed to discuss the proposed sanction. The NOPV proposes a sanction of mandatory completion of the board education course. For those of you who find that a violation did occur, please state whether you agree with the proposed sanction. In doing so, please list the provisions of Section 4201 of Title 19 of the California Code of Regulations that you are using as the basis of your determination and facts that you relied upon. Members who would like to continue.
Member Bianchini, I do believe that there was a violation of 4216.3A1A, and that that sanction, the proper request for sanction of the board's mandatory completion of board education course is the appropriate response to it.
Thank you. Any additional considerations?
Member Munoz agreed.
Seeing no further deliberation, we'll proceed to a motion. I will entertain a motion from the board to take action on this item.
Member Voss, I move to find that the Yucaipa Valley Water District violated Government Code 4216.3A1A and would benefit by taking the board's education course.
A second?
Member Bianchini, I second.
Motion was made by Member Voss, a second by Member Bianchini. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini,
Yes.
Del Toro,
Yes.
Johns,
Yes.
Munoz,
Yes.
Voss.
Yes.
The board's okay. Move it on. The next item before us is an action item on the decision on NOPV to Southern California Edison Investigation 22 LA 01484. Members Charlene and Johnson have recused themselves from this item. Does any member need to excuse themselves for considering Southern California Edison? Seeing no recusals, we will proceed. The notice cited Southern California Edison for two violations. One, Government Code 4216.3A1A, failure to respond to excavators by legal start date and time, and Government Code 4216.3C1A, a failure to provide timely electronic positive response. The NOPV proposes that Southern California Edison be required to take our education course. Southern California Edison has provided a written response contesting the violations. Southern California Edison is under the enforcement jurisdiction of the California Public Utilities Commission. Our decision is whether to make recommendations to the California Public Utilities Commission. We'll begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone. For those on the webinar, press the raise hand button or #2. We will start with in-person comment. Seeing no in-person comments, we will move to the webinar comments. Host, are there any webinar comments?
No hands raised.
Seeing no comments, we will proceed. We will turn now to the members of the board. We will first need to decide if the violation occurred. If we determine that the respondent committed the violation, we will then determine if the proposed sanction is appropriate. I ask that we deliberate on the proposed violations separately. First, Government Code 4216.3A1A, failure to respond to excavators by legal start date and time. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Who would like to begin?
Member Bianchini, after reading all this and Edison's objection letter, the fact still remains that it didn't get marked timely. And I saw no offer of proof that a conversation ever happened between Johnson and without such, I mean, you know, I get complaints from contractors that are told that happens all the time, and that somebody from their office, although either they can't identify them or they identify the wrong person, to try to derail that, and it's concerning. Mm-hmm. I'll just say. So, yes, I do think that the violation in 4216.3A1A did occur.
Thank you.
Member Munoz, I agree. And just to remind everyone, the notification occurred on Wednesday, January 5th, and its intent to excavate with a legal start date and time of 5:01 on Friday, January 7th. And by their own admission, SCE's own admission, they said that the excavator said that there was a no response on January 10th, and January 10th, coincidentally, is when SCE showed up after the 7th, saying that the job was too big to do. Now, again, let's go back to this extremely patient excavator who agreed to do a meet so they can go over this in more detail. But as Member Bianchini said, there was no agreement prior to the excavator reaching out to do all this, and they weren't even done until the 18th. So this was an extremely long time. So I think, yes, they were in violation.
Thank you. We now turn to the second proposed violation, Government Code 4216.3C1A, failure to provide timely electronic positive response. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make a determination. Who would like to begin deliberation?
Member Munoz, I'm okay with education on this one. I think that's fine.
we're focused on if we believe they're in violation of 4216.
Sorry, yes, absolutely. They're in violation for the same reasons that we already said that we've already discussed.
I concur with Member Munoz. Just didn't want to be the first voice every time.
Member Johns, it does appear that they weren't timely in responding. There's that confusion of the operator going out and requesting a meeting, but there's not a lot of documentation for that. It seems to be a trend, and it does appear to me that they didn't receive the response that they needed.
Thank you, Mary Johns. I have nothing further to add from what's already been said. Now that we have discussed the violations, we now proceed to discuss the proposed sanction. The NOPV proposes a sanction of mandatory completion of the board's education course. For those of you who find that a violation did occur, please state whether I think we've already gone through this, if you guys are okay if I move forward.
Member Voss, can I back up just a little bit?
Sure.
I'm a little hard-headed here. On Edison's letter here, they attached the ticket here, and it looks like on page, so this is, they call it in their letter, what, Exhibit 2, Attachment 1, it's kind of confusing. Attachment 1, and it'd be page 21 here, it'd be 0021 is at the bottom of the page, but it looks like there's a code here. It says USCE TT84SE, Southern California has an Edison Transmission Telecom, dated 1/7 at 8:22:15 a.m., indicating a code of 050 saying negotiated marketing schedule. So is that the response? Who put that response in? Would that have been Edison, or would it have been the excavator?
It would have been Edison, because he's saying that they had a negotiated term, but there's no reference to that from the excavator, and that's what I was alluding to. That we get that all the time, and we actually have to respond. We respond to that and say there's no negotiated, and they said, oh yeah, we talked to X, and no X, we don't have an X here, and so this is a response from the operator that they have a negotiated time.
Okay, so going back to your point, so the attachment here from Utiliquest, their representative, right, to Santone Joseph, or no, let's see, from to Valerie McKay, whoever that is. I guess looking at this, the Utiliquest email to somebody, but it doesn't, all they're trying to do is create the history here, right? There's no, what we're looking for is some documentation or communication between Johnson and Edison, right, or Utiliquest, indicating the confirmation of some meet and mark.
Correct. This is very
someone's story here.
Right. This is very typical
Member Munoz.
for a lot of operators.
If you go back to the original, like to our investigation here, it tells you that originally Frontier and SCE provided incorrect electronic positive responses indicating they had no subsurface installations in the area. They did that first.
But was that on the original ticket, or was that on a no response ticket?
It was the original ticket.
The original
so it's all
ticket.
in this timeline here. If you look on starting on page 7.
Madam Chair, is there something, perhaps if I can clarify something?
Please.
And just to the point of the new ticket. So Exhibit 2, as we identified, Bates number 0021, where it, for Southern California Edison, the negotiated marketing schedule that's listed there, that actually was identified by the excavator as appropriate. And that is, you can find that at base number 0041 on Exhibit 3. What the excavator said in that case was based on the fact that he'd identified on the ticket a meet and mark for Monday, the 10th, that he felt that negotiated marking schedule response on the 7th was appropriate.
Member Munoz, so that's kind of where I guess the only question that I had is when did he tell them? Because it looked like since he wasn't going to excavate on Friday, right, January 7th, he thought he could push off the meeting till Monday so they could all meet together and talk, but it didn't say when that occurred. The whole report doesn't say that.
Member Johns, now on my sheet 0023, it's the ticket, and it says on 11 January, telequest for SCE. Respondent said located area marked, and then the next line is 01022. It said scheduled meet with excavator, requested date and time, and then further down it's 011022. It says clear, no conflict. So there is a response by Edison on these.
Is that Edison? That's the Desert.
Well, telequest for SCE.
Oh, there it is.
Yeah, so okay. Desert. Yeah, so to me it seems like, well, there is a form of response.
Yeah, exactly.
Yeah,
including a no conflict.
Yes, that's what the.
Granted, he gave you several options to choose from.
And I think that's kind of the concern we have for Frontier as well. Is they may have a new schedule, but instead of being forthright, they say there's no conflict. Then they say it's marked, and then scheduled to meet with excavator later on the same day. It keeps going back and forth. So I think this goes back to what Member Bianchini keeps bringing up is it's not standardized, the response. And since there's no real there's no real documentation that when they actually finished, because they're going back and forth on these responses, it leaves for ambiguity and confusion when we're just really lucky that this excavator went above and beyond to make sure that everybody cleared before they started work.
So is the board looking at that there was failure to provide timely electronic response or not based on?
So Member Johns, I guess I'm saying, yeah, it does look like they responded. The quality and what they did, I question, and it brings up a different problem. But as far as a response, I'm saying it does appear that they did respond. Okay. I think they added more confusion to the problem and all, but that's a different subject.
So are we all looking at, so we got Exhibit 2. So on Exhibit 2, on that page 23, there's 6 responses there. One says Utiliquest for SCE, and then you have SCE transmitted telecom, and they look like they're the exact same response, duplicated. But in these tickets, and they tell you who's doing the responding? Is it coming from the excavator? Or is it coming from the operator? And I don't know enough about the tickets to know.
On the 5th column, it says by, and that is who is doing the response, and then what the response is.
Who's the buy from that you read there?
Utiliquest. And you're right, they are very, very eerily similar in responses to everyone.
But again,
no conflict.
How can we tell who pushed the button and put in the response?
Responder by.
Responder 5.
It is first you have my paperclip.
You have the member.
the member, the name, the revision, the responded time, and then the by, and then the response.
So where it says utiliquist, that means that the utiliquist.
Yeah, on behalf of is under the
on
name.
behalf of SE, right?
Well, then, yeah, but the guy who pushed the button looks like it's by.
Yeah, a lot of gibberish.
So in order to move this, are we good to move this forward, just so I'm clear on violation 1? There was a clear violation, and are we as a board saying violation 2, that there was not a violation? So I know how to proceed with my motion.
So I guess my confusion in this whole thing is, did the violation for everybody occur after, when the contractor Johnson asked for a field meet, did anybody confirm they wanted to meet with him on Monday the 10th?
Well, my bigger problem with that is he's asking for a field meet because he was told that there was no conflicts, and he knows there's conflicts.
Got it.
So that, he's given an answer that he knows he can't use and he can't excavate yet. So he's saying, get out here, and I'll show you have conflicts, and you should start marking. This is very typical.
Okay. I'm glad to hear all this. Yes. No, seriously, because it's I get it. There, you use the tools you have within the system to get your point across.
That's my problem. Those tools aren't in the system either, other than the no conflict.
You'd want a big hammer to come out. I get it.
Member Munoz, I still feel the same way. I feel that we narrowly averted potential huge issues because an excavator went above and beyond, not because anyone complied with the law. I think he gave them plenty of opportunity to self-correct. But at the end of the day, I think to our chair's question is, I feel that there was a violation.
For 2?
For the second one, yeah, for both of them. So to be very clear, I believe that there is a violation of 4216.3A 1A and 4216.3C 1A, both of them.
Member Bianchini, I concur.
Thank you.
Member Voss, I was just hoping there was a more clear paper trail here on this, but it doesn't look like there is. Other than the excavator basically saying, it's not done yet, get back out here.
Now that we have discussed the violations, we may now proceed to discuss the proposed sanction. The NOPV proposes sanction of mandatory completion of board's education course. For those of you who find that a violation did occur, please state whether you agree with the proposed sanction. I think we already did that, but let's go ahead and do that for formality's sake.
Member Bianchini, I agree.
We discussed the determination of facts that we relied upon. I think we talked about that quite a bit. Seeing no further deliberation, we'll proceed to a motion. I will entertain a motion for the board to take action on this item. I'll take a motion.
Member Voss, I move to find that Southern California Edison violated Government Code Sections 4216.3, A1A, and 4216.3C, 1A, and would benefit by taking the board's education course.
Motion was made by Member Voss. A second?
Member Bianchini, I'll second.
A second was made by Member Bianchini. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini?
Yes.
Del Toro?
Yes.
Johns?
Yes.
Munoz?
Yes.
Voss?
Yes.
Motion is adopted. The board good to move on to 11? Let's do it. Yes, it's the same. The next item before us is an action item on the decision on NOPV to Charter Communications Investigations 22 LA 01484. Member Charlin and Johnson are recused from the item. Does any other member need to excuse themselves from considering Charter Communications? Seeing no other recusals, we will proceed. The notice cited Charter Communications for violating Government Code 4216.3A1A, failure to respond to excavator by legal start date and time. The NOPV proposes that Charter be required to take our education course. Charter has not responded to the NOPV. Charter is under the board's enforcement jurisdiction. We will begin by taking public comment on this item. If you would like to make a comment, please come up to the microphone. For those on the webinar, press raise hand button or #2. We will start with in-person comment. Seeing no in-person comments, we'll move to webinar comments. Host, are there any webinar comments?
No hands raised.
We will turn now to members of the board. We first need to decide if the violation occurred. If we determine that the respondent committed the violation, we'll then determine if the proposed sanction is appropriate. I ask that we deliberate on the proposed violation of Government Code 4216.3A1A, failure to respond excavators by legal start date and time. Please state whether you agree that the violation occurred. In doing so, please list the facts you relied upon to make your determination. Members who would like to begin?
Member Munoz, it's just, it's just in here.
Duplicate, yeah.
It's duplicate, so I mean, it's the same ticket. There was still a lack of response. They didn't respond, so I don't know what.
Yeah.
They don't have anything to express any of this, so I feel there's a violation here.
And Member Johns, I concur that I don't see anything of a response that they had.
Thank you, Member Johns. Now that we have discussed the violation, we will now proceed to discuss the proposed sanction. The NOPV proposes a sanction of mandatory completion of the board's education course. For those of you who find that a violation did occur, please state whether you agree with the proposed sanctions. In doing so, please list the provisions of Section 4201 of Title 19 of the California Code of Regulations that you're using as the basis of your determination and facts you relied upon. Members who would like to continue?
Member Johns, for that, the same. I don't see the response and electronic positive response, so.
Seeing no further deliberation, we'll proceed to a motion. I will entertain a motion from the board to take action on this item.
Member Voss here. I move to find that Charter Communications violated Government Code 4216.3A1A and would benefit by taking the board's education.
A second. Del Toro, I'll second. A motion was made by Member Voss. A second was made by Member Del Toro. Please vote by stating yes, no, or abstain when your name is called. Secretary, please call roll.
Bianchini?
Yes.
Del Toro?
Yes.
Johns?
Yes.
Munoz?
Yes.
Voss?
Yes.
Motion is adopted. Secretary, please invite the members that recuse themselves back into the meeting.
Please allow a few minutes for them to traverse the foyer.
Welcome back, Member Johnson. Welcome back. Given the time, if no board member objects, I suggest that we recess until tomorrow morning. Any objections? Seeing no objection, the board will now recess and resume in this room at 9 a.m. tomorrow morning. Thank you.
A note for those